Father, and Son, and Holy Testament. Dear Lord, we ask your graces and your blessings upon ourselves, our families, our country. We ask you to give us courage, wisdom, not allow our country to be undermined by the enemies of the country who have designs that so many people are aware of. We need your help in this fight, dear Lord, and we ask this in Jesus' name. Amen.
Amen.
Okay, yesterday I left off and we were kind of cut short because of the noise in the next room. I want to just finish that up. Remember I had a long box here, and I was saying this was like your court procedures, going through court. You come in here, you do your complaint and your summons. You do your civil cover sheet. Then you serve it. Then, and remember, before we do this, get here, we're going to do the complaint and summons and give it to the person we're going to sue ahead of time. That'll be his notification, his opportunity. This will be the exhaustion of your remedies, your administrative remedies. If he won't do that, if he won't agree to sit down with you, you have no choice but to go here. So you're all protected then. From that point on, the judge can't say you filed a frivolous lawsuit. If it's frivolous, he should have told you up here in the administrative area. So remember, we do this always. You do these things, you get them served, and the next thing that happens is you're going to get an answer from the defendant. Now, the normal course of things is the defendant would answer paragraph for paragraph. And let me just make this note, paragraph for paragraph. He's supposed to, if you've got 80 paragraphs, he's supposed to answer every one of those. Even with your first paragraph where you identify yourself, he's saying there's no dispute, with that paragraph. Then he has to go down and dispute each paragraph. That is the way it's supposed to be done. What is happening is like we talked about 12b-6. Instead of doing this, they come in with 12b-6. And I really want you to understand this because it's important to understand so you know what they're doing. 12b-6 is saying you failed to state a claim. Well, where did you state your claim? In the complaint. So he's saying that the complaint somehow has a defect in it. The only claim you've made so far is in the complaint. If you don't want, in fact, I'll tell you what, I'll tell you, you probably don't even have to file an affidavit here. File your affidavit when you respond to his answer. It's better that way because then the judge can't say, oh, I didn't see the affidavit, or I didn't see the evidence. I'm pretty sure that would be a better way to do it, even though we've been filing affidavits and exhibits with the complaint.
But you can do both, right?
You can do both, yes.
Because you said you might not even notice the first one.
Right.
Say you didn't have it and you have to bring it back again.
Right. You come back in here with your evidence and affidavits again. Because under 12b-6, that has to be implemented under Rule 56. So let's put Rule 56. Rule 56 says that both parties are given their opportunity then to present their affidavits, their evidence, and everything before the court. Now, I keep trying to explain to you that if you've got everything in order, you should automatically win. This should be a mechanical process. If you've got if you've got an issue in paragraph, let's say 20, and you have an affidavit to support that paragraph 20. And he has nothing, you win paragraph 20. If in paragraph 25, you have a Supreme Court ruling supporting your claim in paragraph 25, and he has nothing to back it up, you win. So both of these, you should win automatically. So now, in Rule 56, I think we're going to have to do a little more carefully in our response to their 12b6 thing. And I think you might be able to state, for one thing, you can firstly tell them he did not give enough sufficient information on which you can make a determination. Okay, now he has to come back and explain what he means. Okay? And the judge cannot award him a dismissal based on 12b6 unless he explains it. Because yours is a denial. So that at that point, it's still a standoff because he hasn't provided the information he needs to provide. So if he comes back then with another answer, now this is going to be in your response. That you're going to answer or respond to his answer. And your response is going to say, defendant did not provide enough information on which to make a determination on 12b6. Now 12b6 won't be the only thing they try to throw at you. They'll try to get it dismissed on the basis of other things like improper service, on the basis of immunity. They'll claim immunity. So you have to answer that, each one of those things. And when the lawyer on the other side is making statements that are designed just to hinder the progress of the case and to hinder the justice that you're seeking, then you should call that to the attention of the court. Say, the lawyer for a corporation XYZ said that the corporation has immunity. The lawyer knows that's not true. Here's the Supreme Court case that says that's not true. And the lawyer should be sanctioned for making a false claim for an improper purpose of delaying this case. You want me to repeat that?
Yes, please.
Okay. Lawyer says the corporation had immunity. And we had a lawyer say that one of the pleadings. Say, the lawyer made the claim for corporation XYZ that the corporation has immunity or is not subject, say he made a claim that the corporation is not subject to the protections of the 14th Amendment. Okay, because they'll say, well, states and officials of the state are subject to the 14th Amendment protections. But corporations don't have a liability under the 14th Amendment. And you can cite the case, the Supreme Court case, and we have that in our important case law. You cite that Supreme Court case, proving the lawyer is wrong. You state that the lawyer is incompetent, and you tell the court that this lawyer filed that issue, brought that issue up for the improper purpose of delaying and impeding this case. Because you want the case to go forward. Now we're talking, you're a plaintiff in this. You want it to go forward. He's trying to get it dismissed. Okay, the 14th Amendment says, actually it takes the, it provides you with all the protections of law that every other citizen in the United States is entitled to. In other words, that's how we get our precedence law brought to us from other states. If a citizen in another state is protected by or has a ruling in law in his favor, saying that, say for instance, he can bear arms. Well, the 14th Amendment brings that into our state too, to me, down to me. So why this whole business of the 14th Amendment makes you a slave is a dead issue. It just isn't true. You should read the Supreme Court case rulings on the 14th Amendment. I've got a whole folder on those. In my library, I have that folder. I just mark it 14th Amendment. And you go ahead and read those court cases. You will understand then what the 14th Amendment did. It was passed for the benefits of the newly freed slaves. It was passed for their benefit. But they couldn't apply it to just a category or class of people. The amendments of the Constitution applies to everybody. So by passing it for that purpose, they also passed it for every other U.S. citizen. Okay, so now we got this, the answer, and what you're going to respond to every issue they bring up in their answer. You may have to get another, he may send out an answer on this. If he doesn't, then that issue is dead. There's no issue there. If he can't explain why he's invoking Rule 12b-6, that issue is dead. And if the court rules on 12b-6, it says we grant the motion to dismiss on 12b-6, you do a void on that judge. Void judgment. So your job is to get past the point of summary judgment. Okay, so once you get past there, now you go to the next step is discovery. Discovery is a very nice tool to force both parties to produce all the evidence, everything they're going to present at trial. It's a preparation for trial. Trial's down here yet. We haven't even gotten to trial. And as we were talking yesterday about witnesses, you know, remember the voir dire? That's got to happen before trial. So if you, in discovery, during that process, you tell the court that your witness is going to be here, this guy, and this guy, and this guy. And these are the issues they're going to testify to. That has to be addressed in voir voir dire. Okay, and probably the judge or the defendant will question your witnesses. In discovery, this is where you're going to really win the case or not. You're going to win it before you ever get to trial. And if you do it properly and you win before you go to trial, you're never going to go to trial. They'll wait until the last day, and then they'll make an offer to sit down and negotiate rather than go to trial. They'll wait till the last minute before trial. They'll come up to you and say, we want to sit down and negotiate. They'll wait till the last minute before trial. So don't think just because they're fighting you every step of the way that they're going to go to trial. They may not be willing to do that. If you do your work right in your complaint, in your brief, in your response, and you get the information you need in discovery on the facts of the case, you've actually won before trial. Now, we know what the judges are going to try to do. If a judge is unfair to you, he's going to try various things to stop this whole process. But let's say you get to trial, and then we'll talk about that on the last day, because we'll be setting up like a mock trial. Remember, we have to have the voir dire, we have to have the jury selection. The defendant and the plaintiff have to stipulate as to what the instructions to the jury are when the jury goes out to deliberate. Now remember, if you got your case set up well, you probably never go to trial. So don't be fearful, but prepare yourself just in case. Yes, go ahead.
What was the voir dire again?
That's to say the truth, to determine the truth of the people that are going to testify, and to see if the jury members are qualified to bring an impartial judgment, to see if the issues the witnesses are going to bring are relevant to the case.
Oh, so do they do like the witnesses first, and then you go into the
Probably
jury
so.
selection?
Yeah, because I've only seen the jury selection, and that is right before the trial begins, before the opening statements. In the trial, you've got three segments. You've got your opening statements. Then you've got where they come in, or you begin your testimony of your witnesses, and that's where you introduce your evidence onto the record. For instance, if you have an adverse witness, you want to question the sheriff. You want to get him on the stand, he's under oath. And you say, you're going to have a line of questioning for him. You might have 2 or 3 lines of questioning for him. One line may be concerning whether he had an arrest warrant, whether there was. Another line of questioning would be, why didn't he answer before we ever came to had to file our lawsuit? Why didn't the sheriff answer? Well, isn't that fraud? And remember, you can ask leading questions because you're a natural person. So, the testimony comes in the middle part of the trial. The expert witnesses, you have to know how to object. And we'll get into that. Some testimony won't be admissible if you object properly. for the other side. You have to know how to push your witness's testimony through. I'll tell you what, in the case of the government, here's what the prosecuting attorneys do, and I'll warn you about this ahead of time. You'll get a witness on the stand, and you'll ask your favorable witness one question. First question. Prosecuting attorney will stand up and he'll say, "Objection, Your Honor." And he'll say, irrelevant, whatever he wants to say, okay? He might say, leading the witness. Anyway, so the judge either sustains or overrules. And I'll tell you one thing that happened to one of our gentlemen. The prosecutor did that, and the judge sat there and he didn't say a thing. He kept his mouth absolutely shut. He just sat there and looked. And our guy was so afraid, he just walked away from the stand, and he said, "I can't do this." Well, he lost his case right there. I can't do this. And that just made me so angry. But anyway, you're going to have the intestinal fortitude to say, Your Honor, the prosecution here is interfering. He's objected on with a frivolous objection, and he's doing this to interrupt the testimony of my witness. I want the jury to hear my witness's statements because it's going to affect the outcome of this case. And if the prosecutor keeps, that would be a defense case, okay? But if the defendant's attorney here keeps interrupting, how can a train of thought or a line of questioning be provided for the jury so they can make a fair and understanding determination? But you have to say those things. They shouldn't have to be said. The judge should tell the prosecutor or the defendant's attorney. He should tell the attorney, you know, you're just disrupting the line of questioning here. You should tell him that automatically. He won't do it because he hates us. Okay, that's a fact of life. So we're not going to try to be nice to the judge. We're just going to be firm and hold our ground. When you get a favorable or an adverse witness on the stand, like an IRS agent, supposing you're questioning him, you're going to say, you ask him the standard questions. What's your name, title, where do you work? That'll warm it up. Warm up the questioning. And then you go into a line of questioning as to, did you receive this letter from me on such and such a date? And you hand the letter, show it to him. And then he'll say, well, I don't remember. I don't read my mail. Oh, well, who received your mail for you? Well, it's my clerk out in the front office. Oh, what is her name, or his name? You get his name. Does not your clerk pass your mail on to you? Do you get any mail whatsoever? Are you just trying to avoid responsibility for taking your job? You run a line of questioning, but you have all your questions prepared for your adverse witness. He's the guy that you're working against. He may even claim the Fifth Amendment. If he keeps claiming the Fifth Amendment that he won't testify, then on each statement that he makes like that, you say, I wish the court reporter to place it on the record that he has invoked the Fifth Amendment, and therefore the judge or this court must accept our allegations on that matter as being true. Yeah.
Can you ask one of the defendants to be a witness against himself?
Yeah.
You can, so you're going to end it.
Well, you don't ask him to be you call him onto the stand.
And can he refuse to come to the stand as a
Only invoking his Fifth Amendment right, and that's what I just went through.
Okay.
If he does that, he loses. That's why this one method that the Patriots got into was the reliance method or something, and they didn't invoke the Fifth Amendment. And they think that would protect them. Well, the problem with that is the court has to make its decision on what's put in front of it. If one side refuses to answer any questions, they have nothing put before the court. Then the court has to accept all the allegations without even proof. They have to accept the allegations as being true, and this guy just hiding. And silence is consent. Remember that old saying? Silence means consent. That's what happens to this guy.
Quitace consuri.
Okay, what is it?
It's quitace consuri. It's a Latin phrase. Silence means consent.
Okay.
Can you write down a board?
Nope.
We'll find the Latin if you want it up there.
I know how to...
Quitace consenturi.
Consenturi.
Yes.
Okay, so qui is
Quiet.
Q-U-I.
Maybe I got it right here.
Okay. But anyway, that would be silence means consent. Yeah, what?
Well, I was just wondering, if he's already become a witness for the opposing side,
Yeah.
is he then open to be a witness for your side, or?
Well, yeah, if he has testified
Yeah,
on behalf of the defendant,
right.
then you can cross-examine him on the same issues he testified for on behalf of the defendant. You can cross-examine him.
Okay.
You won't be able to take the Fifth in.
No, that is right. He can't take the Fifth in. Because the same matters that he testified on before, he didn't take the Fifth in. But even if he took the Fifth on everything, then his testimony means nothing, and all your allegations are accepted as true on those issues you wanted to question him on. I want to mention again, this is like a mechanical process. You have the cannon, he's got the pea shooter, you win. Okay, you got the Supreme Court common law case, he has nothing to oppose it, you win. It's and the judge, if the judge steps out of his line, then we're going to cite the judicial code of conduct against the judge. Now, I just want to stop for a minute because I want to explain something that I learned a long time ago. Years ago, when I was younger, like in my 30s, 40s, it's been a long time. I was like a lot of people. I would say to myself, I can't learn all this stuff. I can't learn all this stuff. You know? Well, what happened, one time I was forced into a business situation where I had to know what I was doing. I couldn't rely on a dozen other people. So I said to myself, well, you know, what I'll do is I'll just learn one thing at a time. I'll read one thing at a time. Don't worry about remembering everything else in the world. So what I did was I started concentrating on what I was reading, not worrying about, can I remember all this? Can I remember? Don't even think about it. Just read what you're reading and think about it. Think hard about it. Because that's the best way to remember things. If you get all the junk thrown out of your mind, and you just start reading that, and you think about it, you think about the various aspects of what's on the paragraph or whatever, you'll remember it much better. So if you say, I can't remember all this stuff, if you think about the logical progression of the trial as you go down here, and then the opening statement, testimony, and the closing statements, you will remember it much better than even if you're trying to take notes. I know a lot of people take notes, and that's fine. For my own self, I don't usually take notes, because if I'm taking notes, I'm writing down stuff and I'm missing what I'm saying up there. No.
I just wanted to say, I wish it worked like that, but when I've gone into court myself and I've submitted my paperwork and information, and I've come across the situation where the judge has said to me, well, the clerk read it.
The clerk read it.
The clerk read what I put in my documentation.
Okay, what was the clerk's,
She was sitting right there, and she said, oh yes, I've read it.
Okay.
Well, I said to the judge, well, I'm waiting for a decision based on what you've read and the information that was given to you.
Yes.
And he says, well, she's already told me what's in there.
Oh, hearsay.
Yeah. So.
That's hearsay, Your Honor.
And I
How do I
said,
know that what she told you is accurate?
he told
Just
me
say
to
that.
get me arrested.
Yeah, but you have to, what?
That's what he said to me. To be quiet, basically, he said, shut up.
Okay, if he says shut up, you say, well, I object, Your Honor, and I will file a objection on paper.
He told me he'd have me arrested if I opened my mouth one more time. That's what he said.
Yeah, well, they think they can do that.
This is my courtroom.
Oh, excuse me. The
He
courts
said-
are set up for the people's benefit, not for the benefit of the judges.
That's what he told me.
I've heard that.
Look,
I've heard that.
I had that sent to me too by Judge Ellen Carmody. This is my courtroom, Mr. Conces. So I let her talk. And then as soon as she finished, I said, I would like to address that issue now. She said, okay, go ahead. Now, here's one thing that you may have fallen into a trap on, and it's something that we all have to be aware of. Even when your opponent, even if he's a liar, let him say his say. Don't interrupt him. Americans tend to have a terrible habit of interrupting in the middle of sentences other people. And it's not a good thing. Practice. That means you got to listen to your wife. Practice.
You made a lot of friends in here.
Oh, yeah, right.
You may not be.
Well, I got a secret for you, Steve. I'm not here to make friends. So you will do yourself the biggest favor in the world if that you will start thinking in terms of listening to what the other person is saying, and listen, intently if that's the proper way to say it. Don't be thinking about something else when he's talking. Don't be thinking what you're going to answer him when he's talking. You think about what he is saying. And you try to figure out what he's talking about. A lot of people will talk and they'll say things. Their meaning, what they really are meaning, is a little bit off point or is a little different than the actual words they're using. So we have to learn when we talk, when we speak, we have to try to use the accurate words and stay on the point, like I keep telling you. Okay? It'll do you good in a court situation, it'll do you good at your home, with your friends. Everybody will like you better, frankly, because you listen to them. People like to be listened to. And then as that progresses, people become more responsible in their speech. I'm telling you, that's true. They no longer are just blowing off their mouths or shooting off their mouths. off the top of their head. All of a sudden they start, gradually probably, they become more responsible in what they say. They're not just going to be reactive, fight back. See, what you do is you disarm a person. If you are listening to them, really what they're saying, and even if you repeat a little bit of it back to them, say, okay, you're saying this, right? Am I right? You can say that to the judge.
He wouldn't let me talk.
Okay, all right. Why did you get to that point?
Well, it was an appeal process.
No, I'm not asking you was an appeals process. I'm asking you, why did the judge get to the point where he told you to shut up?
Well, this is what I'm trying to explain, is that the first time we went to court, I let that person talk. And I basically figured that I was gonna wait. I took my notes, and I was gonna, but it was already too late. The judge had made his decision. He didn't really want to even hear me at that point, so I had to appeal it.
And you may be right.
Okay, and when I appealed it, I did, at that point, interrupt what was being said. And it even made the judge madder. I mean, I figured this way, I at least got something to say. I'm gonna say it this next time around. It's costing me money to appeal these. And it didn't matter.
And you're right, and the judge is supposed to, according to his code of conduct, is not supposed to do things like that.
Should she file a complaint against the judge?
Well, I don't know. I would, because you had issues you wanted to bring up,
Right,
and the judge wanted you to shut up, right?
pretty much.
So you leave after you get out of the courtroom, you go home and you write those issues on paper. And these are your objections to what the judge ruled. And then you file your objections to his ruling. And what went on in the courtroom? You say to the judge, see, there you can address those issues of the judicial code of conduct to the judge. You do it in objections.
But you don't, you have to go through an appeals court after that.
No,
The decisions made, no, they gave me actually,
Wait. No.
they gave me a paper at the end.
No, wait, I'm
court
saying
rules.
going back to the same court.
Yeah.
The same judge, you're telling him where he violated the code of conduct, where he was wrong, and you're voiding his judgment. If he made a judgment, you're voiding his judgment. They give you 7 days in state court to file objections. Once you walk out of the courtroom, the judge says, well, I'm going to rule this, that, or the other thing. They give you 7 days to file objections in the same court. You don't have to just automatically go to appeal.
Well, the situation was, and this is what he told me, if I bring it before him again, he would throw me in jail. He
On
flat out
paper?
said that.
Well, then you're going to have to word it to use proper wording in your objections. You're not going to say it, you're going to write it to him. And you write and you tell him why he's violated his own code of conduct or his oath of office, whatever you think he's violated, and you be very specific and stay on point. And you might have 5 points that you want to bring to his attention. When I first went to court, and I didn't know any of this stuff, I got, the case was dismissed in Calhoun County, Judge Kingsley. And Judge Kingsley kind of looked at me, oh, you're not a lawyer, type thing. Anyway, he dismissed it, and I was kind of mad when I walked out. That's before I learned how to kind of focus my energy. So I went home and I thought about it. About 3 days later, I woke up in the morning and I said, I know what I'm going to do. I'm going to file a motion for clarification. So I filed a motion for clarification. I listed the issues I wanted clarified. Because he had made all kinds of silly statements in issuing his ruling. And they were all orally. But I remembered most of them, and I wrote them down. I said, you said this, you said that. How does that apply in this case? How does that, that's irrelevant. Or I could cite court cases against him, what he said. And I would do that, and I would list the issues. Well, I sent one to the court, one to the attorney for the county. The attorneys for the county responded, sent me a notice that we were going to have another hearing. So we went back to the second hearing. And when the judge came out that time, everybody that was present in our group noticed that he was entirely different in his demeanor, because I had called him on these things. And I was correct. And you know what he did? He backed off on every one of the statements he had made at the hearing, the first hearing. Backed off on every one. He says, Mr. Conces, before I address anything else, he says, I can't get past the first thing, that all the defendants had immunity. He says, if you want to appeal that, Mr. Conces, you can appeal it. So, but I wouldn't, even today, I would not let him get away with that. I would say, well, Your Honor, I will file a paper within 7 days on that issue of immunity. And then I file another motion for clarification on immunity. But see, you can do that, and the judges don't like it, but what can they do? They have to hear you. That was a hearing. They have to hear you. So I want you to be aware. Okay, you had some questions, some folks. Yeah.
Yeah, I just want to know if you could file if she could file a void judgment on that ruling at any time.
If she had sufficient reason, yeah.
But there's no time limit, I guess.
No, there's no time limit on void judgments. Now, in the court rules, it says like you got a year or something. But we have the court rulings that say, no, they can even be done 15 years later. Because a void judgment basically is stating that the judgment that the court made was null and void from the beginning. It never had any force, effect, or law. It never existed. The judgment never existed. So that can be done anytime.
It's going to be done after you've appealed the case.
Yes, you
Go
can.
back and void the
Yes, you
original
can. I could go back today to that case, and I could void that lower court, and I could void the appeal court where I went to appeals, because they were blowing smoke and mirrors all the way, and I knew it, but I could void it today. So you've got, in your trial, you've got opening statement, testimony, and then your closing statements. And remember yesterday I told you on closing, if you're a defendant, you get the second closing statement, and then the prosecution gets the third, a small 15-minute closing statement. If you're in a civil trial, I'm not sure who does the closing statement first, but it really doesn't matter. I think you each get one closing statement. So make your closing statement good and stay on point. Don't talk about how mean the other guy is. If you know, some lawyers do that. I think some lawyers do that, and they do accomplish what they want to get. If it's real close to the whole issues that are brought up, you can get into, you know, related issues of his attitude or something like that. You certainly can bring up the issue that he refused to answer you. That's fraud. And then you cite the court ruling to the, and you've already entered that court ruling onto the record. And the jury has to use the record to make its determinations. The trick that the judges have been using is try to keep everything off the record that the Patriot offers, and let the government get anything on the record they want. That's their trick. That's where you have to be pretty tough. So you need to get things entered on the record through testimony.
Chuck, we're talking this morning at breakfast, just the thing about if even a patriot wins their case or whatever, and then the judge seals, you know, that from being open to the public, isn't that sort of doing the same thing?
I don't think they seal it because our cases are on the public record. You can get them on the internet. I don't think they're sealed, and they're not going to seal them after the fact if everything was revealed. The only thing that, you know, might be sealed is statements a jury member might make after the trial. You know, I don't know. I don't know if they could even do that, but there has to be some important reason for sealing a verdict or something like that. Like, for instance, if somebody's life is in danger or under threat, or there's a national security issue, they can't just seal whatever they want to seal. It has to be a sufficient reason.
But what if they did seal something? Is there anything that the person could do then to try and get it unsealed, or?
Are you talking about it that's been dismissed?
There's been a verdict, but then there's...
Why would you want it unsealed?
Because if it was...
If you won the case, why would you want it unsealed?
Well, won the case, I'd want it unsealed so it could set precedents.
Well, you can tell everybody what happened. You can do it in your own words. I don't think that's an issue. Christine, I don't think you're going to run into that. If you want a case against an IRS agent, they're not going to seal it.
Not with the internet.
No. Yeah.
You said that you got 7 days for an objection to file that?
Yes.
What about a motion?
Well, a motion for void judgment, yeah, you can do a motion for void judgment.
That can be done your motions can be done anytime, or?
Well, a motion for a void judgment can be done anytime. But other motions, you should file them within the 7 days, I think. You know, like another motion for clarification on other issues. Say that other issues were raised in the hearing. And you want those issues addressed now and then list them. You have a right. Didn't Clarence Thomas say you have a right to all the findings and conclusions of the court? On all issues of law, fact, and discretionary matters. So use that. Now, if the state judge says, well, this is not a federal court, you say, well, if there's a conflict between federal law and state law, federal law prevails. And this is federal law, Your Honor. This is federal law. And you have sworn an oath to uphold federal law. He won't like it, but what's he going to do?
You shut up, out of the record.
You just shut up, Rollins. Don't even look at me,
I think a
Rollins.
lot of judges do that to everybody, that's why they don't have nobody fights anymore, you know? And I can see exactly what she's talking about, 100%.
There's no respect at all
Yeah.
whatsoever. They just,
But we don't know what to do, and that's why everybody says, well, shit, I'm not gonna try my case, look what he did to
he
me.
flat out said, I will throw you in jail, just say one more word.
Okay, just shut up and then write your objections after the trial, when you have time to think. See, because a lot of times in trial, you're just tossing things off the top of your head, and sometimes you get into irrelevancies and things like that, and you're not saying, look, don't shake your head no, because I know everybody does this. Everybody
What I'm
does.
saying is I had everything written down, the points that I had to make.
Okay.
Everything was
Okay.
very organized.
Did
The letters I
you submit it to them in a paper?
Absolutely. That's
Okay.
where the clerk read it.
Okay, so then he said he wasn't going to address those issues?
He flat out said he was aware of the issues. He was informed by his clerk.
Okay, and you should have asked him, well, are you going to address those issues? I have a right, every party has a right to all the findings and conclusions of this court.
Well, when I even mentioned anything about his, to his clerk, well, I didn't want the clerk. Well, the clerk is fine. I trust her. I don't have a problem with that. And he just went off.
Not focused enough.
It was not a good
Is
situation.
that issue she's not focused enough? She's not focused on his responsibility to become an issue with the clerk and it got off track?
Well, I don't know, it'd be hard, you'd have to actually be there to listen to what happened, and I'm not gonna shoot my mouth off and make statements I don't know issues on, but I'm just telling you what you could do. You could shut up.
I did.
Now, what would you do, the next step? What would be the next step?
I let it go. Because I had already filed 3
I told you not to
times.
let it go.
I had already filed 3 separate times, and I went before that same judge.
Okay.
And each time something happened like that, and he told me, the next time you file and bring this before the courts, if it's frivolous, I'm throwing you in jail. If I consider this frivolous, you will go to jail.
Well,
And I just let it go.
it can't be frivolous if the Supreme Court of the United States tells him he must give you the findings and facts on every issue of law, fact, and discretionary matters.
When he says that's his court,
No,
he's making,
well,
and I
okay,
understand
all
what you're
right,
saying.
okay, you got a mindset here. I'm telling you,
I
you
got
got
a
a
weird
mindset.
judge is what I got.
Look, we all got rotten judges. We've all got rotten judges, and we have to learn how to deal with them. But if you got a mindset that says, I can't win.
We had a judge that said he wouldn't tell us why I was dismissing the case.
Yeah, you know what we did? We
He
sued
wouldn't
him.
even tell us.
We
So
sued
we
him.
run into that. We sued him. Yeah.
Did you win?
No, not yet.
Yeah.
Not yet, but listen, we don't let our cases go because we know we can go back years later and open those up anytime we want. And you know what? It lays a paper trail, and that's why we can vacate all those judges.
Now, I had to
That's
transfer.
why I'm telling you, you have to make them responsible. And quit this stuff of saying, I quit.
We have that judge on record as saying that he wouldn't tell us. I have a written transcript. But we sued him in federal court, and they know that there's no way to defend against what this judge did. He violated his oath of office. He did a number of things by claiming that he wasn't going to tell us. So we have that. We have the evidence. It's irrefutable evidence. And so this is where the same position you want to put the judge that you're talking about in.
Yeah.
He's made outrageous and crazy statements. Okay, so get a copy of that court transcript where he said all that. Yeah.
But then, like for instance, if you're going to make allegations at them, and do it on paper, and do it in a logical form. I told one of the judges, the federal judges here on paper, that he has damaged the U.S. district courts, and he's rebelled against the laws of the United States and the Constitution. Said that's an act of, no judge should be allowed to hold office under those conditions. I told him on paper. He didn't even respond to those statements. So I told him, look, Judge, you're a moron. That's what I told him. No, I didn't say moron. But in other words, in official words, and I cited the Supreme Court rulings and the court rules that gave me the authority to say that he would damage the United States.
Does everything apply to a probate court situation then too? Because I'm dealing with probate court.
Well, I don't know. I'm not sure. I won't say anything on that. I don't know. Yeah.
Can I just ask, what happens? She files the objection within time.
Yeah.
What does she expect next?
I don't know what she expects. I know what I would
What would I
expect.
expect next? What would I anticipate?
Get an answer.
Would it be in the
But see, here's what you do. You file your objections, and then if it's like a state court, you make a prayer at the bottom to the court. You ask the court to do something. The prayer at the bottom, if you don't ask the court to do anything, then it's just a statement to the court. And the court doesn't have to respond. But if you make it the prayer to the court, and then you cite why he has to respond. And we have the Maritime Port Authority case. So we can tell the judge he has to respond on these issues. And plaintiff respectfully demands that the judge respond to these issues.
This Citizens for Legal Responsibility on the net
they want to hear about things like this, and they will publicly put it in their list of, and here they say they want, they're currently needing more information on the misconduct of attorneys and judges, and then they want you to write, and they will put it publicly in here. And they do not, the judges and lawyers don't want to be publicly.
No.
If you can publicly embarrass them, that's something. And this here.
Well, I'll tell you another thing that's going to happen to these judges. I gave them a time period to respond. By the way, yesterday somebody sent me this ruling, and I'm going to pass it out, by the way, so you have it. Let me read you this ruling. The U.S. Supreme Court in Schurer versus Rhodes, 1974, stated that, quote, when a state officer acts under a state law in a manner violative of the federal Constitution, he comes into conflict with the superior authority of that of the Constitution. And he is, in that case, stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct.
Wow.
The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States.
I guess I don't, well, that's going to be in the next letter.
I'll tell you, you know what I did with that? I put it in our elephant letter to the Attorney General's now.
Oh, I was just saying.
That's perfect for Mr. Cox. So our next letter to Mr. Cox is not going to contain that. Yeah, but I want that cited to all the Attorney Generals across the country. He is stripped of his official or representative character.
Are you going to put that on the Lawman, on the website? So, I mean, just send it out to everybody.
Well, I tell you what, it's going to be in our paperwork, and it'll be available for all the groups.
Okay.
Yeah, it'll be in the letters that we send out, so you'll see it.
Yeah, that's fantastic. And a reminder.
And you know what? I checked it out.
And a reminder to the, remember we talked about a reminder in the notice of vacancies that there's only so much time remaining for them to respond?
Yeah.
That's got to go right there.
Right.
Yeah, see, then that's just wonderful.
Yeah, it'll go exactly with these judges and what they're doing.
Yeah.
Now, let me finish the statement on what's going to happen. We've given them a time frame to answer. We'll extend the time period a little bit longer, maybe a week longer. I'm going to send a letter to the judges again. You have failed to respond. I'm going to cite that court case for you. And then I'm going to say, we will now publish publicly on the record for all citizens to know that you have vacated your office and you do not dispute it.
If you don't respond.
Well, they haven't. They've refused already.
Oh, I know that. I know they have. But notifying them of their lack of response also, I think it'd be a good idea to tell them that this is the authority that we're acting under, which is
the Supreme Court,
the Constitution, and you got about if you don't still refuse in the face of this, that we'll have to make it public.
Okay.
Give one more chance.
Let me read it one more time just for the video so that people on the video. This is U.S. Supreme Court case Schurer versus Rhodes, 416 U.S. 232. And I did check this out, that it's an accurate quote, 1974. When a state officer acts under a state law in a manner violative of the federal Constitution, he comes into conflict with the superior authority of that Constitution. And he is, in that case, stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. In other words, he can be sued.
Can't be any more clear.
Yeah, as an individual. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. There's your answer to judges' immunity. All judges have immunity. Baloney. When they act outside of their authority, they act in their individual capacity. There it is.
Chuck, would that include county and municipalities?
Yes, it would. Any official, judges include. I've got.
Now, would that also mean
Police officers.
they would have to hire their own lawyer that wouldn't come out of our pocket?
Yeah, right.
See, that's out of our
It's in
country.
his personal capacity.
A lot of our township officials are doing this, and every time they get called into court, we pay for their lawyer. They don't care how long it takes.
I know, but this will be, that's why you really need to sue these people in their personal
Yeah.
capacity. I've got a few of these, and I'm going to pass them out, one to each table. Just make sure everybody gets a chance to see that. This is also the judicial code of conduct. We got one more table back here. So pass them around, so people can look at those cases, and then we're going to go through the judicial code of conduct now. Pardon? Oh, well, you got to pay for them. If you want copies for that, I paid for half of the last stuff. Okay, so if you want a copy, ask the lady to get you a copy, and you pay for it. Yeah.
So with this notices that you send to the judges about them vacating their office, what are the possible outcomes of that?
Well, the probable outcome is that they no longer get a salary from the federal government, that they no longer are entitled to their retirements. Their judgments at the point where they repudiated their oath of office, any judgment after that would be null and void.
Very serious issues.
Yeah. Yeah, we're not messing around with these people anymore.
And then they have to get a real
So
job.
do you expect that to happen?
That's what we're asking for, is real judges now for the Western District of Michigan. What?
Do you expect that going to be happening in favor of?
I don't see how it could not happen.
I see. So that's a
They've
big.
already vacated their office.
So that can become big news, right?
It can become very big news, because we're going to publish it in the newspapers if the judges won't respond to us.
Doesn't matter.
But
But what can they say? Everything is on record, so
That's right.
they cannot.
That's right. We have proof, witnesses. We laid the paper trail. That was the important thing. Lay the paper trail. Give them an opportunity, notify them of their wrongdoing. Give them an opportunity to respond. If they refuse to respond, that's fraud. And then you notify them that you're going to publish it in the newspapers.
Is there a time frame, like once you notice somebody that they've done something, broke the law? Like when we break the law, they arrest us right away, put us in jail?
Well, I'm not asking for criminal charges at this point. I think we will. We will. But right now, all we're asking for them is a response.
What I'm saying is,
That'll
what kind of
probably happen.
response? Within 10 years, or? That's what I'm trying to find out.
I can't answer that.
I mean, like I say, they arrest us
Today.
like right now.
Today, there's probably no prosecuting attorney that would arrest a judge. Or no judge issue an order for the arrest of another judge. That is today. A month from now, that may all change. But how will we know unless we do it?
Well, I understand that, but that's what I'm saying, is evidently they can choose not to answer or just ignore or whatever. As
If they
do
choose
it all along.
that, what's going to happen to them?
I don't know.
No, I'm telling you what's going to happen. They're going to be publicly called out.
The problem is nobody's done this.
They've all given up. I quit. How many times have you heard, I quit?
If Judge
I'm afraid,
McKee-
I'm scared.
If Judge McKee or Judge Carmen had a case before them, someone came into their courtroom, filed a case, and they were assigned that judge, and they knew what went on in the way of having the charges filed against those judges. All they would have to do is present that and demand that that judge recuse themselves based on the allegations, based on the criminal complaint that's been filed against them.
Yeah.
That's all you have to do. And so once this becomes more public, these people, they'll lose their ability to do anything.
Yeah.
So, I mean, it's just a matter of it will happen. You're saying when it will happen. It may happen real quick.
Yeah, but I mean.
But it might not happen for a year or two, but it's going to happen.
Yeah.
Same with Mr. Cox.
They're scared to death at this point.
Mr. Cox can't win re-election if he is going to take the position that he's taking right now.
If he's got a steady income coming after he doesn't run again, what does he care?
No,
He cares.
he cares. They care a lot because it's not just their money. That's not the issue here. It's not what their money they're getting. That's not, the issue is, how do we get rid of these corrupt judges?
Exactly, yeah.
Okay.
I agree with that. I mean, what is the time frame going to be? If we do prove this, is there going to be a time limit after that? If the judge does go crooked again, he's got 90
I
days.
just told you that.
No, he
We
can't
don't
get
give him
bonded.
a second chance.
They don't get a
We don't
second.
give him a second chance. He's had his chance to respond.
about another
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 judge,
official, any official.
I tell you what, judges are going to be having Monday morning meetings. How are we going to deal with this? Yeah, it's a sales meeting, like the sales. How are we going to sell our customers here?
I mean, as I mentioned, all right, any official that is accused of wrongdoing and found guilty within, let's say he has to go to trial within a year, not 10 years, not 20 years, later on, and then all of a sudden he gets found guilty, a time limit on everybody when they violate their oath of office.
Well, I mean, like I'm saying, what exists today may not exist a month from now.
Well, I hope not. I'm just saying that they just not answering. And
I can't answer your question.
Yeah, because this is the
They
way
can
the
appeal it
bank,
in the
nobody's
ground.
done it.
Look, I don't have a crystal ball. I'm not a mind reader. I'm not a fortune teller. I can't tell you. So everybody asks that question, well, who's going to arrest this guy? I can't tell you that. But I'll tell you what, people are thinking about it right now.
People are getting injured.
Yeah.
I just have a real quick question here, because that one line that says, the federal constitution, he comes into conflict with the superior authority of that constitution. Are they talking about like Michigan?
Any constitution, that would apply to any constitution.
Well, I'm trying to figure out that constitution. meaning-
Because they are subject to both constitutions. Every official in the whole United States, and every state government official is subject to the United States Constitution.
Okay, and each state has their own constitution.
Yes, on top of that.
Okay,
But we're mostly talking about the federal constitution.
okay.
Yeah.
Chuck, when you talk about a motion for a void judgment, does a motion have to be ruled on by a judge?
Yeah.
So the judge would have to find their own finding void?
No, their own judgment void.
Excuse me, I'm sorry, their own.
Actually, what you're doing is you're telling the judge that that is already a void judgment because of this reason. Now, you want him to declare publicly that it's a void judgment. That's all you're asking him to do. Even if he won't declare that it's a void judgment, it still is, because of the other court rulings. See, we got tons of court rulings saying to void all this junk that they've done on the 12b6s. You could, Richard Coyford brought this out in his video, you could void probably half of the judgments in this whole country for the last 25 years. And you would have a massive shift of wealth from one party to the other. And then we might get some justice here. But I'm telling you, this is what's so good about it. We're just following the law. And that's what's so nice about it. And that's why we're going to win. The only way that they can stop us from winning is drop a nuclear bomb on us.
Don't say that too loud.
I know. We don't want to give them ideas, right? Yeah.
You know, Chuck, under Rule 60, you can ask for a judgment, for relief from an order of a judge under Rule 60, and under 64, 60B4, that the reason that states is that the judgment was void. So you can actually, you could do that. You can make a motion for relief from his order based on that rule and cite that court rule. And say, well, your ruling was void, and this is the reason it was void. I mean, that's another way to go. And give the judge a chance to void his own ruling, to make it official and
I've got
grant
an
your
extra part
motion to
here.
vacate.
You guys need,
Motion
I've got
for
about
relief.
5 sheets of the first part of the
Yeah.
issue.
Yeah.
Kind of, yeah, just pass mine. I got my own copy, here's the first one.
Now
It's
Chuck,
just the
what
first
if
sheet.
you went back with a void judgment, there's been a few years in between time, and even if that was corrected, or the judge recognized that the judgment was made, wrong?
Yeah.
Can you then turn around and sue for damages that have been caused to you?
Yeah, because he's acted outside of his authority, and we have this Supreme Court ruling that we could rely on.
And then would you sue the judge?
You could do that, you could sue the judge, you could sue the attorney, but you better get smart,
Yeah, right.
learn how to do it right.
Right.
Give them notice, an opportunity to respond before you do the lawsuit. Then if they fail to respond or refuse to respond, then they're sucked. They're sucked. They're scared of this stuff. And it's about time.
Well, like you said, most lawyers don't even know anything about constitutional law anyway.
That's right.
Or any of the
Right.
And that's something we got on, I think, really.
We have,
Trying to understand it.
we asked the lawyers in, we wrote a letter to the law firms around Grand Rapids. And not one of them would represent this fellow in the tax case, because they said we don't have a lawyer. We're not confident in tax law. That's what most of them responded. So, really what they're saying is they don't want to. That's what they're really saying. Yeah, okay, George.
The issue that I have going on with the building block permit that I've been dealing with, I corresponded twice with the courts, and they've yet to answer any of my responses to them. This letter that you just read about the officials, would I send it to the court, or would I send each one of these representatives of the corporate city, of the zoning office, a letter that what you just read there?
I'm not sure what your issue is, because it could be an issue that the zoning law didn't say what they said it said. It could be an issue that the zoning law was improperly passed. It could be an issue of you're having a grandfather clause on your property. I think you do, because you've been there a long time.
Yeah.
They have a grandfather clause that exempts you right off the bat. So you could have a lot of issues. Have you looked up the grandfather clause?
No, I've never been able to find anything on it.
Well, all you have to do, if you got a question, you go back to the city or the county or the township. You say, I want to see the ordinance. If the ordinance does not cite the state law that you can go look at, then you say, well, the ordinance is invalid, because it has to cite the state law on there.
They falsely accused him because he did not build a building. He maintained an old building that'd been there for 100 years.
Yeah, well, that's a grandfather clause.
And the law says that you can't, that you're supposed to maintain your outbuildings, so everything they did was unlawful.
But wait a minute, the law, does the law actually say that? Because I'll tell you what, that would violate your constitutional right of your property, private property.
It was something.
See, I'll bet you haven't even read the law that they're saying, it said what it said.
Well,
See, you have to go and look at what they're trying to apply to you.
We looked at this only.
I believe in one of the letters that they, when I finally asked for a copy of the complaint, and I also asked for a copy of the bench warrant, they never sent me a copy of the bench warrant. They
Right.
didn't send it to me.
Right. But that's just a letter, and that's fraud.
But in one of the letters, they did state the code that I violated in building without permit.
Did they send you a copy of the code?
No.
go to their office
I
and
gotta
say,
go back
I
and
want a
read that.
copy of the code.
Right.
That's exactly what I'm telling you to do right now. Everybody needs to do that. Go right to them. They get scared to death. Oh, you mean I actually have to come up with a copy of the code that I'm trying to enforce here?
But Chucky also has to read the state law.
Yes, he has to.
Use
But
that code to enforce.
you go to the code first. The code has to state the state law, cite the state law. You go to the state law, see if the code says what the state law says. Let me give you an example that is hilarious. It's the funniest code, and the Michigan Township Association tells the townships to write this code. It's the 344, Public Act 344 of 1945. And if you look at the Public Act, it says all kinds of things. It says the township may do this, township may do that, township may do this. That's for the restoration of property like alleys, street lights, streets of a bad area that's been run down. And they're saying that state law, that Public Act, they can impose a $500 fine on a person for not having a license plate on a car that's parked on his private property. They're saying that.
Oh, man.
Now, if you go look at the Public Act, there's not one penalty involved in the whole Public Act. Not one penalty cited in the whole Public Act.
I just got a citation.
Well, I would love to do that. You know, if I were you,
I'll bring the ticket in tomorrow.
No, I would go to, don't wait for him to bring the ticket in. No, confront them, go to them and say, I want discovery.
I know,
Now,
the trial's in 15th of
because then you could lay the paper trail on it.
Oh, I'm going to do it.
Okay, but discovery will lay the paper trail on it.
He did put in writing for them to submit in writing the code he violated, and they wouldn't answer.
Okay, ask for discovery. You have a preliminary hearing, right? What's the preliminary hearing for? Is it so that they can find out how to prosecute you?
Well, I'm going to paper them up. I'm going to.
No.
The code says that I violated no motor vehicle that's supposed to be licensed by the state can be unlicensed, and also any inoperative vehicles.
That's baloney.
I know.
But can you prove it?
Well, the cop doesn't. How can the cop prove that the vehicles are
No,
inoperative?
no, I'm not asking you to do a negative argument. How could you say, how can a cop prove this? No, that's not a good argument. Do it in a positive way. You go to the code or the ordinance. It'll cite on there 344 Public Act of 1945. You go read the Public Act. You copy it off the internet. You take it into them and say, I want discovery. Show me who authorized a fine on me and my private property. You want to know who did it. Because if it's the township lawyer, you want to take him to the plaintiffs.
The first thing you've got to do is plead not guilty, okay? Then you get your, if you haven't already denied it.
I'm going to deny everything.
If you deny it
No,
formally?
I haven't denied it yet.
Well,
I'm
you gotta
going to
do
send a
that.
form in to deny everything, and then ask them for a discovery.
But don't you get your preliminary hearing before? Yeah, I guess you have to deny it.
And then they say, they demand that you get a trial, and they'll.
They give you a preliminary.
I do a
your
statement
preliminary trial.
affidavit with a discovery.
Is it going to be a denial or not responsive?
And then
I'm deny everything with particularity.
I'll bring a discovery order and show you what it looks like.
From a court.
From
See,
a court.
in the preliminary hearing, you can ask for discovery from the judge. And the judge will, if the prosecutor won't answer questions, the judge will answer.
Well, I like to default them before it even comes to trial. That's what I try.
Okay, well, you can do a statement of facts later
That's what
on.
I do.
Okay. Okay, let's go on now. Have we settled ordinances?
That's a whole other class.
Yeah, but you know what? The ordinance issue is very easy because they violate the law right off the bat. and you could bang them on that. Then you could lay the paper trail on them and sue them.
Just one more thing, Chuck. I've seen where they send ordinance such and such, and ordinance such and such, and you violated this and that. And if you actually come right down to it, I'd rather than my picture was. That's my right. I object. But,
So
but
what?
a lot of times, if you look up the ordinance, it doesn't even correspond to the complaint.
Yeah.
A lot of times it doesn't
That's what
even
I'm
match
saying.
yours.
There has
So
to
if
be
you don't
a
look it
link
up-
between the ordinance and the law.
Right.
And if there is no link between the ordinance and the law, and that is done by the citation, and then citing the purpose that the law states. So they have to pick that purpose off of the law, the public act, because it's stated on the public act. Then they have to paste that onto the ordinance. And if either one of those conditions are not there, the ordinance is bogus.
Don't they also have to have something in their charters stating that they're adopting the state law? Don't they have to make a statement?
That's in the law that says they adopt the law. Yeah. They can't legislate. We have the Attorney General opinions from Michigan, it's Frank Kelly. And he had a lot of good opinions and issued a lot. And one of them was that the only legislative body, or the only thing that can be called law, is that which is passed by the state legislature. In other words, it's not law if somebody says the township passed a law. They didn't pass a law.
But the city of Detroit passes a law through their city council and so on and so forth?
Nope.
That is not, unless it...
That's all bogus. The only, I'm telling you, the only law-making body, and even Frank Kelly, I will dig him up, and he will confirm what I'm telling you.
There's no authority for those.
There's only one law-making body in the whole state of Michigan.
That's it.
Only one. Because the Constitution only authorizes one law-making body for the state of Michigan. Every Constitution is like that. So, well, let's finish up with this. You got your opening statements, testimony where you introduce your evidence for on the record. And then if you're cross-examining an adverse witness and you get him to admit to something that you want to place on the record, like for instance that he has never seen a delegation order in his life. Your Honor, I would like that placed on the record that the IRS agent here has stated that he has not had has never seen a delegation order. You could ask the IRS agent, have you ever read Code Section 7608 and hand it to him in his face? And he'll look at it and say, well, I don't know. Well, do you understand? Have you read it and understood it? Do you understand that what it says about you and agents of your title? Well, I don't know. They don't tell us this stuff. Your Honor, I don't wish to enter onto the record that the IRS agent says that their administration and the supervisors do not tell or instruct their employees properly, and that they violate law with regular regularity. But I mean, you place that stuff on the record. I want that placed on the record, Your Honor. Then the jury has to consider that in its deliberations. So, and remember, it's so important to know how to do objections. We're going to try to do some objections today and just kind of practice. Now, trial, supposing you get a judgment in your favor for damages, then you have to collect them. Now, there is a court case, a Supreme Court case that I've seen, where it says a judge should issue an order for collection, authorizing, your collection against the defendant.